Yes, in this case, that is Criminal Appeal number 26 of 2024, we find that the victim child has not been examined, and therefore we find it appropriate if the matter is remanded back before the learned trial court for examination of the victim child to make sure that she understands the importance of speaking the truth, and also to ascertain that she understands what she is deposing before the court. Accordingly, Criminal Appeal number 26 of 24 stands disposed of as above, and in appreciation of the services rendered by the learned amicus curiae and the learned legal aid councils, their fees will be paid as per the prescribed norm.
Hello, Raj.
Seek your Lordship's indulgence in making a mention in respect of item number 2 and 3 of part 2.
Yes.
Although the matters are fixed for today, my lord,
Oh, what happened?
I am down with cold, so I don't think I'll have the vocal energy for a full hearing in 2 cases. So I would like, if this matter may be posted again after 2 weeks if possible. I'm for the petitioners in both cases.
Okay, have you taken the consent?
Yes, I
from
have.
the
Yes, I have. Mr. Lal Sanyal.
Mr. Lal Fakoma, learned counsel for the petitioner, has prayed for adjournment of the matter with the consent of the other side. In view of the above, list after 2 weeks.
I would like to seek your Lordship's indulgence yet again, my lord, in respect of one unlisted matter. It's a transfer petition. If there's urgency in this matter, if this matter may be taken up tomorrow, if possible.
Okay.
Deeply obliged.
Motion item 1.
My lord, I have some personal problem and may this matter be passed over for today and listed on tomorrow.
Okay, on the submission made by Ms. Jacinta Zotanmoy, learned counsel for the petitioner, list this matter tomorrow.
Mr. Place.
Item 2.
Put the date, okay?
May please your lordship. My lord, this petition has been filed for claim of compensation for the non-payment of compensation to the petitioners who are landowners within the National Highways 06. We need this stretch of land extending from 54.6 km to 69.015 km at Kozol district. The petitioners were at the initial were not included in the 3A notifications under the National Highways Act, and up until the 3G notifications, due to the fact that their lands would remain, they were of a firm belief that their lands would remain untouched. But when constructions had reached their land, their lands have been encroached by the respondent authorities. And may I take your lordship to Annexure 7? There, my lord.
Page, Annexure 7 is page?
It starts from page 56. The respondent number 5, Kala, had sent.
So when notice was issued, you didn't respond, is it?
It was not included in the list, my lord.
Okay. Okay,
And-
fine.
yes.
Yes.
And
Right.
subsequently, it was declared as a missing plot by the respondent number 5. The lands of the petitioners were declared as a missing plot, and a request for 3A notification was to be published, was sent to the general manager, to the respondent number 4, by the respondent number 5, and the lands were verified, and a reply was sent again by the respondent number 5 to by the general manager, PMU Selling.
Okay, so there was a spot verification
Spot
done on
yes,
23/08/2024.
Yes.
Okay, in spite of that, you have not been given compensation, is it?
Yes.
So
my
what is the finding in the spot verification? That your land is encroached?
Yes, my lord. It has been Annexure 9, my lord. May I take your lordship to Annexure 9?
Page?
Page 61. Here, my lord, the Kala has stated that it does not require any re-verification and stands on the previous report mentioned. So there is no dispute regarding the ownership or the issuance of the land. So basically, they are entitled to the compensation amount which was paid.
Okay, we'll issue notice.
My lord.
Heard Mr. Rukung Apautu, learned counsel for the petitioner. Then, new para. The writ petition filed under section 2, article 226 of the Constitution of India is for the issuance of the appropriate writ or order to the respondents for payment of compensation to the petitioners on their encroachment of their landed property at Kozol,
Dulte village.
okay, at Dulte village. Let's stop. The learned counsel submits that when that the petitioners are landowners within the stretch of land from 54.6 km to 69.015 km. And their landed property was encroached on the construction of road by the respondent authorities since the said land falls within the construction of road within the NH/06. Stop. On the representation submitted by the petitioners, a joint verification was also held on, when was it held? Joint verification report, I just mentioned the date on, when was the date?
23rd August 2022.
On 23rd August 2022, wherein it was ascertained that their landed properties was encroached upon. However, the respondents have failed to pay the compensation due to the petitioners till date, hence the instant writ petition. This court find it fit to issue notice to the respondents through registered post. Notice to the respondents, okay, full stop. Then, Mrs. Caroline K. Lalungoypui, learned government advocate, accepts notice on behalf of respondents number 6, my lord. Respondent number 6, while Ms. Zoram Sangpui, learned CGC, accepts notice on behalf of respondents number 1 and Mr. Samuel L. Sangte, learned counsel for NHIDC, NHIDCL accepts notice on behalf of respondent number 224. No need to issue formal notice. Have we
Five, my lord. 5 is required.
to the said respondents, notice be issued to respondent number 5 through registered post with AB within 3 days, returnable by 3 weeks. List after 3 weeks. Meanwhile, requisite copies of the writ petition to be duly furnished to the learned counsels for the respondents. Yes.
I'm obliged.
Item 3.
Yes, none appeared for the petitioner on call. List after 2 weeks.
Item 4.
Good morning, my lord. Our matter pertains to violation of principles of natural justice and procedural irregularity. I will explain if my lord permits me.
Yes.
I and defendants had a mutual agreement to pay back 4.7 lakhs to defendants. I was granted 47 days to perform our agreement. However, after 3 days of our agreement, defendants rushed to Loca dalat Aizol and filed a petition against me to perform our agreement. Then the Loca dalat Aizol proceeded the matter.
So were you present in the Loca dalat?
No, for the petitioner,
Let's see the award.
award is in page number 17, my lord.
17. Okay, this is the award made by the Loca dalat, and you are, what's your name?
Mine,
Lal
Lal
Luzwala. So you're saying that you were not present? No, your signature is there, Lal Luzwala.
yes, my lord.
Then
May I explain my
you've come
grounds,
to an
my lord?
amicable settlement. You were there.
My lord, actually, this, while there was a valid contract, the Loca dalat proceeded the matter. This is against the violation.
But,
This is
but
violation.
you were there.
Yes.
See, if you come to an agreement, previous contract or whatever doesn't make any difference. If you agree, if you come to some sort of an agreement and you sign to that agreement willingly, previous contract, whatever, doesn't make any difference.
But my lord, you know, any person who never had a legal dispute are always very nervous before any type of legal proceedings.
Nervous or no nervous? How old are you? What's your age that you should be nervous? You must be a grown-up man. You come to Loca dalat, you sign, you come to an agreement, and then you later appeal against it saying, I was nervous. That's not a case for you. So what did you say in your writ petition, that you were nervous or what?
No, ma'am.
Then
No, my lord. Shall I explain my grounds?
at para?
At para 6, page number 6.
Yes.
While I had a sufficient time to perform the contract agreement, the respondent filed a petition before Loca dalat without a complete cause of action. This undermines my rights.
This is not a court. Loca dalat is not a court where cause of action, no cause of action. You come, you are there, you are sitting there with the respondents. You come to an agreement, and as per your agreement, you all sign on the agreement. Whether there was a contract, what?
My lord, if we see the section 22D of the Legal Services Authority Act 1987, may I read?
Wait, give me the Legal Services Authority, sir. See if it's there, legal services, it should be also there. Yes, anyway, 20?
22, the page number 15. The permanent Loc Adalat shall, while conducting conciliation proceedings or deciding a dispute on merit under this act, be guided by the principles of natural justice, fair play, objectivity, equity, and other principles of justice. Here, defendants, they are undermining my rights to perform the original terms of agreement. This is violation of principles of natural justice.
You will have to say whether they were forced or not. Isn't it? And this is concerning permanent Loc Adalat. Now, there are two types of Loc Adalat, okay? One is the permanent Loc Adalat. Permanent Loc Adalat, it's headed by most probably the district judge, and a permanent Loc Adalat and the normal Loc Adalat is different. So 22D is not applicable in this case. It's not, doesn't have anything to do with public utility or public services. So read 22, there is Loc Adalat or permanent Loc Adalat. Read section 22. There is a permanent Loc Adalat and a Loc Adalat. Okay, so 22B talks about establishment of permanent Loc Adalat. So what you're reading, 22D, is regarding permanent Loc Adalat, not the Loc Adalat where you were called.
My lord, the defendants dragging me into Loc Adalat proceedings. This is against the objective of consensual and amicable settlements, where there was a leak contract.
Contract or no contract, if you come to an agreement, your
Yes,
contract
agreement.
gets cancelled. You don't want to go as per your contract, you have come to a settlement at Loc Adalat. If you have settled the matter at Loc Adalat, then that supersedes your contract. Maybe there was something wrong with your contract and you said, okay, let's settle the matter at Loc Adalat. You have settled it. I don't know whether you'll have a case or not.
Actually, ma'am, we had an agreement. While it was valid, they were forced me to enter
How
into
can
Loc
you be
Adalat.
forced? That's what I'm
Yes.
thinking.
Because they have filed a petition before Loc Adalat. Then the Loc
Ah,
Adalat
then you
proceeded the
shouldn't have
matter.
gone to Loc Adalat. You should have said, I don't want to come to a settlement. You cannot force in Loc Adalat. If you don't want to settle the matter in Loc Adalat, you say, we have already come to a settlement. I'm not going to appear in Loc Adalat. I don't want to settle the matter. And the matter is not settled in Loc Adalat. Isn't it? I'm trying. What are your grounds that you were forced? I don't think that. How can you say you're forced? How many members were there? You can't accuse the, unless there's something in the agreement which is completely wrong or something. Have you read the award?
Yes, ma'am.
Then
I'm ready.
you take your writ petition back. Okay. Read it carefully, the award, because if that is not your ground, and you file afresh, because the grounds which you have raised now is not acceptable, but there could be a ground for which you can go against, you can question the legality of the Loc Adalat award. So you take the writ petition back, withdraw, read it and see.
Yes.
Because I've just read the award now.
Yes, my
But
lord.
saying that I was forced, I wasn't willing, I was forced to go. How can you say that? Was a warrant issued against you that you were forced to go to Loc Adalat?
At this stage, no.
No, then there was one case where we had set aside the Loc Adalat award because warrants were issued against her and she was compelled to go. And then there was also some aspects of the award which the legality of the award was doubtful. Okay, but you saying that I was compelled, there was a contract already existing, then you don't have to go to Loca dalat. What did you go and put your signature? You didn't have to, you were not forced to go. But there is something in the award which I've just read where maybe, but you have to raise that point yourself, not this court.
Yes, my lord.
Anyway, so Mr. Francis Lian Moya, learned counsel for the petitioner, who has prayed for withdrawal of the writ petition with the permission to file afresh. Praise aloud. As prayed for, writ petition is allowed to be withdrawn with the permission to file afresh. See,
That's
there
fine.
is a ground, but you have not raised that ground here.
Obliged, my lord.
Submission item 5 and 6.
Yes.
May I please also? May I please also?
Yes.
My lord, last occasion, my lord, there's a question, the question was raised by
Yes,
the learned
yes, that
friend.
has, so let's see the office note. We said the office should put
Yes.
up a note.
Yes, ma'am.
So office note dated 2105. Whether you were, you had filed your wakalatnama. Yes, here it says that he has filed his wakalatnama on 24/02/2025. So this person, respondent number 5, he's going to have 2 counsels or what?
Yes, my lord. Yes, my lord. Earlier, no, because I filed
Yes,
writ petition,
because
my lord.
Ms. Zairam Sangpui was saying that I am the counsel and I've filed my show cause reply also.
Yes, my lord. My lord, what happened, my lord?
This is in your
Uh,
private capacity that you are engaged, huh? Yes.
Yes, my lord, private. My lord, what happened, my lord? This one, I filed writ petition, the which is and the item number 6, my lord. Item number 6, I filed writ petition, my lord. In that case, my lord, I have annexed all the documents and the challenge the assessment of the order of the district collector, my lord. And
Okay,
thereafter, my lord,
yes.
I also annexed the affidavit filed by the
Yes, yes.
respondent.
So now you have filed your wakalatnama. It's
Yes,
clarified.
I filed.
So you can
Yes, my lord.
appear in the contempt also.
Yes, my lord.
Now,
My-
the petition is
my-
ready. Can we go ahead with the case? Yes.
Yes, my lord. I filed additional affidavit also in this contempt petition, my lord.
You have filed? Or
Yes,
you
my lord.
want to file? You have
Already filed, already filed.
Already
Already
filed.
filed.
Huh? Okay.
So 24th February 2005.
The additional affidavit filed in the contempt petition, have you received it? When did you
Yes.
file it?
Yes, my lord.
24th February.
Okay, fine.
My lord, if the matter may kindly be taken up after 2 weeks, my lord, or fixed on 2nd of June, if
What
possible.
happened? You're here? They are
Yes,
here.
my lord, but I was not ready because I apologize. I was not ready because of the commotion regarding the Wakalat Nama and all, my lord. So if the matter may kindly be taken up on June 2nd, my lord.
My lord, then my lord, I'm coming physically, my lord, 16 and 17, dear my lord. Matter
my
will
lord.
be fixed on, my lord,
16th
17.
and 17th
17.
June.
My
Yes,
lord,
madam.
2nd of June, my lord, we have already adjourned court dates on his timings always. So if the matter may be kindly fixed.
Madam,
No, but
on-
you're here. 16th, we'll make it 16th. What's 16th June?
16 or 7. 16, so many cases I fixed, my dear. 17 is okay, my lord.
17th.
Yes, my lord. No, I am ready. Today itself I am ready for him, my lord.
He's
Today
ready,
itself I am
but
ready.
since you are praying, 17th is, so you've prayed for the month of June
My lord.
anyways,
My
okay?
lord.
So, heard Miss Valentina Laldinpui, learned counsel for the petitioner, who has prayed for adjournment of the matter, which is not objected by the learned counsel, by Mr.
Excuse me.
S.K. Medi, learned counsel for, and Ms. Zairam Sangpui, learned counsels for the respondent number 5. Yes, the state is also a party here. Are you aware? No, but in the contempt, Who is appearing for respondent number 1 and 3?
Miss H. Swami, my lord.
Okay, none appeared, while respondent number, yes. And Ms. H. Malswamy, learned counsel for respondent number 1 to 3. They've prayed for adjournment, which is not objected. Okay. In view of the above, as prayed for, list on 17/6/2025. Yes.
My lord, order case, my lord.
Orders, item 7.
Yes, it is listed with WPC, it will come.
Yes.
Yes,
May I please, Your Lordship? This is the third time we have filed bail application before this court.
yes.
It's a matter relating to 21C of the NPS Act. My Lord, there are new grounds which I would like to raise before Your Lordship today. It's with, one aspect is with regarding long incarceration. Another aspect is with regard to grounds of arrest. In the light of the recent Supreme Court judgment and the judgment which is recently delivered by this court as well, my lord. Your Lordship has passed and dismissed my previous bail order, my lord. I'll take Your Lordship to that order. Page 32, my lord. The relevant portion is at part 33. I'm sorry, 33.
Page 33.
Yes, my lord. The order is dated 22/8/2024. If I may read this with Your Lordship
Yes,
permission.
yes.
Only one prosecution witnesses have been examined so far out of the 12 witnesses. Therefore, it appears...
Till date.
No, no.
Oh, when this, okay,
when
fine.
this order was passed.
Okay.
Therefore, it appears that the trial of the instant case is going at a snail pace. In view of the above, in the interest of justice, this court finds it fit to direct the learned Judge Special Court and the NPS Act to make an attempt to complete the examination of the prosecution witnesses within 4 months from the date of this order. My lord, from 22/8/2024, that 4 months would have lapsed on 22/12/2024. Now, since the passing of that order, 8 months and 22 days has already lapsed. Now, I'm in custody for about 1 year, 10 months. 1 year, 10 months, as on today. Your Lordship will see that there are 12 prosecution witnesses in this case. 4 were examined.
Okay, till date, it's only 4.
4 were examined. One seizing officer in respect of the present applicant, and another seizing officer in respect of another accused who was already released on bail, who was arrested at a different place. Now, the other 2 witnesses are the judicial magistrate, and the other one is the witness in respect of the Bolero vehicle, in which the seized article was allegedly seized. Now, till then, my lord, the trial has not gone successfully, if I may say. It has not proceeded as it has to proceed. Your Lordship may kindly come to the order passed by the Learned Special Court subsequent to the filing of this dismissal of Your Lordship Order 22/8/2024, my lord, page 72.
72.
Of my application, my lord.
Yes.
Now, subsequent to the dismissal of my bail application by this honorable court, an order was passed by the Learned Special Court, calling upon the prosecution witnesses to appear on a specific dates, my lord. PW 3 and 4 on 15/10/24, PW 5 and 6 on 29/10/24, PW 7 and 8 on 12/11/24, PW 9 and 10 on 26/11/24, PW 11 and 12 on 10/11/24. The PW 3, 4, 5, and 6 are summoned on that date. None appears. Thereafter, on page 74, Your Lordship will see the subsequent order of the court, special court. Here, it appears that PW 7, 11, and 12 are absent. Summons not returned. PW 8 is also absent with cause. Now at page 75. Summons were again issued to appear on this date. PW 3 and 4 for 22, 125, 5 and 6 for 29, 125, 7 and 8 for 5, 225, PW 9 and 11 for 12, 225, and PW 12 for 26, 225. Now, the applicant herein was produced before the Land Special Court on 14/5/25. 14/5/25. And next date is fixed for examination of PW 3 and 4 on 28/5/25. Now it appears that, my Lord, Your Lordship will see from the orders passed by the Land Special Court, we have a disinterested prosecution witnesses in this case. Your Lordship has made a specific direction to complete the trial within a period of 4 months. Now, my case is covered by the judgment of the Supreme Court, where long incarceration, my Lord, Section 37 of the NDNPS Act will not come in the way of long incarceration, my Lord. So I would like to produce
Yes.
citation with that regard.
What is the citation?
In this Sariful Islam case, my Lord, the petitioner was incarcerated for about 1 year, 6 months, my Lord. It's a case of NDNPS.
So read the relevant paras or read the whole order.
It is short order, my Lord, with your Lordship permission. Our Learned Counsel appearing for the petitioner, Learned Counsel appearing for the state of West Bengal, and carefully peruse the material available on record, taking into consideration the fact that the petitioner is reported to be in custody since 27/1/2021 and has suffered incarceration for over 1 year, 6 months, and there being no likelihood of completion of trial in the near future, which fact cannot be controverted by the Learned Counsel appearing for the state, we are inclined to grant him bail. The petitioner is therefore directed to be released on bail subject to such terms and conditions which the concerned trial court may deem fit and appropriate to impose upon him. With regard to long incarceration, my Lord, if your Lordship may allow me to produce several judgments, I have brought this judgment of the Supreme Court as well, and this Honorable Court, my Lord.
This is for how long?
This is for 1 year, 9 months
Incarceration
Yeah.
in this case.
in this PC Larin Moyes case. Now I am in custody for about 1 year, 10 months.
Under section,
This
in
is
the
under
cited case?
NDNPS case.
Under which section?
C, my Lord.
21C.
21C.
And in your case?
My case is also C. Now, I'll also allow me to produce some more.
You don't need too many, 1 or 2 recent ones is enough.
For my benefit, my Lord, if I may be allowed to.
This is the apex court, okay.
This is the apex court, Nitish Adhikari case. Here it is 21C. Now the petitioner therein was in custody for about 1 year, 7 months.
Anyway, what is the seized article?
It is 2 cases of heroin from the secret compartment driven by the applicant hearing. I'm the driver of that vehicle, and there was a co-accused with the co-passenger, and another accused who was alleged to be the owner of that seized article was arrested at Vairengte. We were arrested at Seling.
Okay,
No.
so the real owner you're saying has been arrested. He's not released on bail?
He was arrested and he was released on bail.
The owner of the vehicle? Or the owner
No,
of the,
the owner of the vehicle is not in this case, my lord. I am the driver of the vehicle and the co-passenger is the co-accused. And another person whom the investigating officer had alleged that he was the owner of that seized article, he was arrested at Vairengte, but he was released on bail by the London Special Court. So since nothing was seized from his possession, my lord. So that is the reason why he was released on bail. Now, if I may come to the other point which I would like to raise, madam. Here in this case, the grounds of arrest was not communicated to the applicant hearing at the time of arrest. They were not communicated in writing, which the law mandates that the grounds of arrest should be communicated to the accused at the time of their arrest. Your Lordship may kindly come to page 40.
let's see the arrest memo.
Yes, my Lord. Report.
Page,
Seizure and arrest memo is at page 42. If I may read this, my Lord. I, Lord Sawa, Sub-Inspector of Excise and Narcotics, do hereby seize the undermentioned articles on this day, 28 August 2023, at 10:45 p.m. at Sealing. I also arrested the undermentioned accused for possessing the seized article on the same day, time, and place in presence of reliable civilian witnesses. The seized articles were recovered from between the steel floor lining of the seized vehicle. The seized articles are mentioned and the arrested persons were also mentioned. The intimation of this seizure and arrest were given to their relatives by means of phone number.
so his wife was informed
Now-
with phone number?
This is the difference which I'm going to argue on this point, my lord. The Honorable Supreme Court has specifically mentioned in Pravi case that the reason for arrest and the grounds of arrest are different. Now, if there is no separate grounds of arrest communicated to the applicant, the arrest and the remand, subsequent remand is vitiated. So if the arrest is unconstitutional, the subsequent remand is illegal. That is what the Honorable Supreme Court says in Vihan Kumar case and Pravi case.
So we'll have to see because the arrest, he has been informed to his wife with his phone number. Yes, let's see a judgment,
I'll produce a judgment.
whether your judgment will be applicable in this case or not. Let's see.
According to me, my
Report of
lord,
address.
it clearly
Report
covers
of
my case.
addresses here. Forwarded
Now, if I may take your lordship to the Honorable Supreme Court judgment, 2024,
especially when he's caught with red-handed, I mean with the vehicle where he's driving, obviously he must be knowing why he's arrested. So let's see the judgment, whether the facts are different or not. Yes.
2024,
Citation. You don't have the copy? No.
I think I have signed it there.
Oh, yes. Is it here? No. Okay. Yes. What is the
2024,
citation? 2024,
8
8
SCC 254.
SCC 254. Yes.
Now,
Para? Or,
my lord, this case at para 26. I'll start
Wait,
from my
wait.
lord.
Para 26. Come to para 26.
Yes, my lord. From a holistic reading of various
Wait,
judgments,
let's be ready first.
my lord, I'm sorry, page 278.
See, I have the screen here. So search for para 26.
It's page 278.
Now we have come to para 19, B1 26. Go up. Oh, yes. Yes, 26. Yes. Yes, you can read.
Now, I'll read this, my lord, with your lordship permission. From a holistic reading of various judgments pertaining to the law of preventive detention, including the Constitution bench decision of this court in Hari Kishan, wherein the provisions of Article 22(5) of the Constitution of India have been interpreted, we find that it has been the consistent view of this court that the grounds on which the liberty of a citizen is curtailed must be communicated in writing, so as to enable him to seek remedial measures against deprivation of liberty. At para 28, the language used in Article 22(1) and Article 22(5) of the Constitution of India regarding the communication of the grounds is exactly the identical. Neither of the constitutional provisions require that the grounds of arrest or detention, as the case may be, must be communicated in writing. Thus, interpretation to this important facet of the fundamental right, as made by the Constitution bench while examining the scope of Article 22(5) of the Constitution of India, would ipso facto apply to Article 22(1) of the Constitution of India insofar as the requirement to communicate the grounds of arrest is concerned. Para 29. Hence, we have no hesitation in reiterating that the requirement to communicate the grounds of arrest or the grounds of detention in writing to a person arrested in connection with an offense or a person placed under preventive detention as provided under Article 22, Clause 1 and 22(5) of the Constitution of India is sacrosanct and cannot be breached under any situation. Non-compliance of this constitutional requirement and statutory mandate would lead to the custody or detention being rendered illegal, as the case may be. At para 13, furthermore, the provisions of Article 22(1) have already been interpreted by this court in Pankaj Bansal case, laying down beyond the pale of doubt that the grounds of arrest must be communicated in writing to the person arrested of and accused at the earliest. Now, I'll come to para 37, Mano, page 280. With your lordship permission, the interpretation given by the learned single judge that the grounds of arrest were conveyed to the accused in writing via the arrest memo is unacceptable on the face of the record. That is why I have made submission that the arrest memo is different from the grounds of arrest memo. Because the arrest memo does not indicate the grounds of arrest being incorporated in the said document. Column number 9 of the arrest memo so is being produced herein below simply sets out the reason for arrest, which are formal in nature and can be generally attributed to any person arrested on accusation of an offense, whereas the grounds of arrest would be personal in nature and specific to the person arrested. What do we mean by reason for arrest? As decided by the Honorable Supreme Court. Number 1, prevent the accused person from committing any further offense. 2, for proper investigation of the offense. To prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in any manner. To prevent such person from making any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the police officer. As unless such person is arrested, his presence in the court whenever required cannot be assured. Now I'll jump to para 46, page 282, Malon. Now coming to the aspect of as to whether grounds of arrest were actually conveyed to the appellant in writing before he was remanded to the custody of the investigating officer. We have carefully perused the arrest memo and find that the same nowhere conveys the grounds on which the accused was being arrested. The arrest memo is simply pro forma indicating the formal reasons for which the accused was being arrested.
Okay, so let's look at the memo of arrest now. We'll stop at that.
My lord. Now, I'll read this again. The intimation of this seizure and arrest were given to these relatives by means of phone numbers so and so. Now, there is a fundamental difference between arrest memo and grounds of arrest.
Okay.
What Article 22(1) says is that grounds of arrest has to be communicated to the accused.
In writing, okay,
writing.
then,
Now, there is a difference which the Honorable Supreme Court has made with regard to reason for arrest and grounds of arrest. At para 48, with your lordship
48,
permission, I read this
yes.
again, my lord. It may be reiterated at the cost of repetition that there is a significant difference in the phrase reasons for arrest and grounds of arrest. The reasons for arrest, as indicated in the arrest memo, are purely formal parameters to prevent the accused person from committing any further offense for proper investigation of the offense, to prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in any manner, to prevent the arrested person from making inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons would commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest would be required to contain all such details in hand of the investigating officer which necessitated the arrest of the accused. Simultaneously, the grounds of arrest in form in writing. My lord, I'll just rephrase this one. Simultaneously, the grounds of arrest in form in writing must convey to the arrested person all basic facts on which he was being arrested, so as to provide him an opportunity of defending himself against custodial remand and to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with the reasons for arrest, which are general in nature. At paragraph 50. As a result, the appellant is entitled to a direction for release from custody by applying the ratio of the judgment rendered by this court in Pangkas Bansal. Now, my lord, I have also produced Pangkas Bansal case 2024-7 SCC 576. Yes, Your Lordship, got it? Page 597. Para 42. I'll start from para 42, my lord. That being so,
wait, let's come to the page.
597 is the page number. And this is a case relating to Prevention of Money Laundering Act, my lord.
Okay.
That being so, there is no valid reason as to why a copy of such written grounds of arrest should not be furnished to the arrested person as a matter of course and without exceptions. There are two primary reasons as to why this would be the advisable course of action to be followed as a matter of principle. Firstly, in the event such grounds of arrest are orally read out to the arrested person or read by such person with nothing further, and this fact is disputed in a given case, it may boil down to the word of the arrested person against the word of the authorized officer as to whether or not there is due and proper compliance in this regard. In the case on hand, that is the situation insofar as Bansal is concerned, though ED claims that witnesses were present and certified that the grounds of arrest were read out and explained to him in Hindi. That is neither here nor there, as he did not sign the document. Non-compliance in this regard would entail release of the arrested person straight away, as held in V. Senthil Balaji's case. Such a precarious situation is easily avoided, and the consequence thereof can be obviated very simply by furnishing the written grounds of arrest as recorded by the authorized officer in terms of Section 19(1) of the PMLA Act to the arrested person under due acknowledgement instead of leaving it to the debatable ipse dixit of the authorized officer. Now, in this case, it discussed about the necessity of recording the grounds of arrest, which should be communicated to the arrested person. So this Pangkas Bansal case has been referred by Prabir Purkayeksta. Now, in the case of Vihan Kumar, 2025 SCC Online, SC 269. Now here, my lord, It also discussed about the grounds of arrest. It discussed about that referred to Pankaj Bansal case and Prabir Purkai Extra case. Mano.
Yes, para.
Now, here it refers to Pankaj Bansal case at Paraten, page 8. Now, I'll come to the conclusion, my lord. The conclusion what was arrived at in this Vihan Kumar case. Para 21.
Yes.
Pardon me, my lord, I'll just come to para 16, page 13, before I come to the conclusion. The last sentence, which starts from para 16. With your lordship permission.
Yes.
Once it is held that arrest is unconstitutional due to violation of Article 22(1), the arrest itself is vitiated. Therefore, continued custody of such a person based on orders of remand is also vitiated. Filing a charge sheet and order of cognizance will not validate an arrest which is per se unconstitutional, being violative of Article 21 and 22(1) of the Constitution of India. We cannot tinker with the most important safeguards provided under Article 22. Now, the conclusion arrived by the Honorable Supreme Court is at para 21, page 15, my lord. Therefore, we conclude, has your lordship got it?
Yes, yes.
The requirement of informing a person arrested of grounds of arrest is mandatory requirement of Article 22(1). B. The information of the grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which he understands. The mode and method of communication must be such that the object of the constitutional safeguard is achieved. Here, in this case, the seizing officer did not know that whether the accused can speak or understand Mizo or English language. In my case, madam. Now at C,
It
when
will be so difficult if they are not from Aizawl, then in their language, then it will have to be either in Bengali,
Yes,
Assamese, or
in a case of this custom and DRI, normally they get a translator, madam. Normally they get their statement translated. That is what I have experienced, my limited experience, my lord.
okay.
C. When arrested accused alleged non-compliance with the requirements of Article 22(1), the burden will always be on the investigating officer agency to prove compliance with the requirements of Article 22(1). Non-compliance with Article 22(1) will be a violation of the fundamental rights of the accused guaranteed by the said article. Moreover, it will amount to a violation of the right to personal liberty guaranteed by Article 21 of the Constitution. Therefore, non-compliance of the requirement of Article 22(1) vitiate the arrest of the accused, hence further order passed by a criminal court of remand are also vitiated. At F, I'll go to F. When a violation of Article 22(1) is established, it is the duty of the court to forward order the release of the accused. That is my humble prayer. A violation of Article 22(1), which is so sacrosanct, cannot be taken lightly by the investigating officer or the prosecution, my lord, in this case. That is why this honorable court, a coordinated bench of this court, has released the applicant on bail due to violation of Article 22(1). If I may be allowed to produce the judgment.
One judgment, okay. One judgment will suffice. The most recent. Because it will be the same thing over and over.
This is the most recent judgment that is pronounced on 25/25. Now,
In 23/5,
25.
25, huh?
Yes.
Yes.
Now, the petitioner therein was in custody for about 463 days. And he was arrested for possession of 3.642 kgs of heroin. In my case, it is 2 kg. Now, he was in custody for 463 days. Now, the coordinate bench of this court has discussed or relied upon the Vihan Kumar case, Prabir case, and has released the applicant therein on bail, my lord. In that case, there were 8 prosecution witnesses and 3 witnesses have been examined. So since in this case, I was in custody for about 1 year, 10 months, which is a pretty long days, my lord. And in fact, your lordship has seized this matter regarding the long incarceration and has also directed the London Special Court to complete the trial within 4 months. That has not been complied with. Rightly or wrongly, the prosecution witnesses were also, we can understand at this point that they were disinterested because the London Special Court has issued summons several times to them and trial could not be completed. So his constitutional rights due to long incarceration was also violated. Article 22.
Yes. Anything else?
There is my humble praise that to release the applicant on bail, considering his long incarceration and the violation of the grounds of arrest under Article 22.1, Section 50 CRPC and the corresponding 52.1 of the NDNPS Act.
But is he innocent?
He is innocent, madam.
You have not taken that plea at all?
I'm sorry, I'll just take that because I have taken that grounds in the previous application also. He is innocent and he will comply with the direction of this court if he is released. Your lordship, if your lordship may allow me to read his statement. If that
Where?
page 49. Now the statement is written in Mizo, page 49. The translation is at page 50A. Even though I have raised,
Read the relevant portions, okay?
my lord,
Yes.
I'll read from 50B, my lord. 3 lines from the top. It starts with Zakira. My lord, may I read within
Yes,
Mizo?
yes,
Mizo.
yes.
Zakira chon kan kalna kong ngaya let le to lawa kong danga kal to turin min ti ama se eng wanga kong ngaya let lo tur nge ti kan zo chuan Zakira chuan motor noya box secret chamber oma chu ta chon bung ro om thu min thila motor noi kan chu kan enai box chu pathum lo nge ya chu mi wang chon kan kalna kong ni lo ho tur chon kan chuk ta ni kong kan thiat lo vain phone a in be chung selin kan kala ma se tol cheng kan thlen chon signal a chia kan in be thei to lo wa kong kan bota kal ngai na kan thilo na da na kan let lia motor brake pipe achi ta wagin motor a kan riek ta a atu son hi pare thlari san ni son hi patum jing dar sari vela champhai panin kan kala new champhai kan thlen brake pipe kan sim ti ra kan sim zo chuan e zon lampanin kan on chuak le ta ni zandar sari le cham le pm vela siling da exercise narcotics duty ten min no ti dinga civilian witness ten kawa an mulai chun kan motor chuan cheka kan motor noya box oma chuan hero da chu an mu chuak ta a excise and narcotic duty te chon heroin chu amuna an bu ka 2 kg aritani excise and narcotic officer chon ke le ka handle man le kan motor nen chon min man tani. Now looking at the statement of the accused, they knew that there was a secret compartment on being told by Zakir while on the way, not from the initial journey, but they did not know. There is not even a faint statement which suggested they knew about the seized article or seized heroin being kept in this secret compartment because Zakir has specifically directed them not to open them. So,
Okay, so you didn't know you were innocent, huh?
Yes,
Okay, fine. Yes, anything else?
so I beseech this honorable court to release me on bail based on what I have submitted on the grounds that I have submitted, Your Lordship.
Yes, Your Lordship. Yeah, my lord, I would like to submit and rebut his first submission regarding the long incarceration. And my lord, in this regard, it is seen that the trial court has tried their best, and there may be circumstances regarding the workload of the trial court and my lord, communication problem. So in this regard, the trial court, it is seen that the trial court has inverse of the trial. So solely on the grounds of long incarceration, the accused cannot be released on bail. And there is a strong presumption that there is a reasonable belief that he has a knowledge and conscious possession. And conscious possession is one of the most essential element regarding the NDNPS Act, my lord. So in this regard, on the grounds of sole incarceration of the accused cannot be a reason to grant the accused on bail. And my lord, regarding the seizure and arrest, and in this regard, my lord, I would like to take you to page 42. That is the memo which the council has already cited.
42.
Yes, my lord. Yes, my lord, here it can be seen that the present appellant had put his signature, Bakul, and it can be seen that he can write in English, and which shows that he knows English. And in the memo, my lord, it stated that the intimation and this seizure and arrest were given to their relatives by means of phone. And my lord, it is true that it is not written, that it is given them to in written. But my lord, there is no question regarding that whether they were given in written or not. Even the seizing officer is already crossed by the council in the trial court. And even
Okay,
that
great.
no question was raised regarding the violation of Section 50 of NDPS Act. So my lord, in this regard, there is no violation of any mandatory provision of NDPS Act, and there is no constitutional violation, and the accused is not liable to be released on bail on this ground. And my lord, under Section 37 of NDPS Act, there is a strict provision regarding release, the accused to be released on bail. And my lord, in this case, the quantity of the seized contraband is a commercial quantity. And looking into the seriousness and the gravity of the offense, my lord, the accused is not liable to be released on bail at this stage. And it can be seen that the trial court is on verge, and the trial may be finished in a very,
How many witnesses left?
Eight witnesses.
4
Out
witnesses
of-
were examined.
Out of 12, 4 examined, 8 left, is it?
Yes, my lord. So, my lord, looking into the gravity of the offense and the menace and the impact on the society, the present appellant should not be released on bail at this stage. It is my humble submission.
Okay,
If I may be allowed to rebut that one point, my lord.
which one?
My other friend has said that no question was asked to the seizing officer regarding the grounds of arrest. Your lordship will see at probable case. It is upon the prosecution to show that Article 22(1) was complied. So she cannot shift the burden on the accused. It is on at the time of arrest whether this has been complied or not. So there is significant difference between arrest memo, which my other friend has just pointed out, and the grounds of arrest. So since grounds of arrest were not communicated to the accused at the time of arrest, my lord, my humble prayer is that since this coordinated bench has also released other accused on bail regarding violation of Article 22(1), it is my humble prayer that I may also be released on bail, my lord. Since this is not the first time that I have come before your lordship. 4 bail applications have been filed already.
The judgment which you cited is 2024, is it? 2024, 2025. Recent ones.
Recent, my lord, very recent. And similarly, in a case of 467 forgery case, celebrated case in this state of Mizoram, Mahindra Finance case, accused was also released on bail. In that case, with regard to violation of Article 22, I can also produce that, Madam.
Okay, but sometimes when you're too technical, you have to look into the menace which is
Yes,
caused in the society.
I
also.
understand.
The court also has a duty to protect the society.
I understand that
Against
question.
crime, isn't it?
That question will come up before either the prosecution or this court. So that is why I came up with a Sanjay Chandra case. I understand that will be raised by this court
Yes.
because it has been in the news. This paragraph 40, page 63. Because there cannot be estoppel against violation of Article 22.
Okay.
Para 40, my lord.
40.
40, page 24. With your lordship permission, my lord. The grant or refusal to grant bail lies within the discretion of the court. The grant or denial is regulated to a large extent by the facts and circumstances of its particular case. But at the same time, right to bail is not to be denied merely because of the sentiments of the community against the accused. The primary purpose of bail in a criminal case are to relieve the accused of imprisonment, to relieve the state the burden of keeping him pending the trial. At the same time, to keep the accused constructively in the custody of the court, whether before or after conviction, to assure that he will submit to the jurisdiction of the court and be in attendance thereon whenever his presence is required. My lord, in this case, I am ready to appear before the learned trial court at any time when I am called. Because this is the fourth time which I have filed bail application, third time before this court.
Even then, 4 or 5 times, if it's the 5th time, you have to do that. Anyways, yes, I've heard Mr. C. Lalfakzola, learned counsel for the petitioner, along with Ms. Vani Siame, learned additional PP for the state respondents. Okay, I'll give my reasons, whatever. Then, in the end, bail is granted with a bail bond of rupees 1 lakh, and with one surety who shall be to the satisfaction of the trial court.
I'm
Okay,
deeply
rest,
obliged.
I'll pass the order later.
Deeply obliged.
Item 8.
Looking at in the mental order. Yes. Yes. 8.
May I please your lordship? My lord, this IS 73 of 2025 is filed by the private respondents in the connected with petition seeking for stay of notification dated 7/4/2025, whereby the MPSC had advertised limited departmental examination for the post of health supervisor. The present case, the connected with petition is pertaining to challenging the promotion of the private respondents to the post of health supervisor by way of LDE. And in the meantime, my lord, during pendency of this petition, this advertisement was made inviting to fill up 17 posts by way of LDE. So the purpose and reason for filing this stay application is that, my lord, in the event the writ petition is allowed in favor of the writ petitioners, the private respondents numbering may be 8 from the bottom, were likely to be demoted to the health supervisor.
Are
And
they
with-
all this thing represented today?
Yes, my lord.
Both the parties are represented?
Yes, my lord.
Okay. Okay, so let's see the notification or advertisement or what, where is it?
Page number 49 of my IA, reading page number 49, Annex 5. This is notification dated 7th April 2025.
Last date of application is already lapsed,
Yes, my lord. Yes,
9/05.
my lord.
So now what is left is only for the notification, is
to
it?
conduct the examination,
Okay, examination not
which is
conducted
not
yet.
yet scheduled.
So you want to stay of this order?
Yes, my lord, the recruitment process during pendency of the writ petition, or to await outcome of the writ petition.
See, this is just a notification, advertisement or notification for applying to sit for an examination, isn't it?
Yes, my lord. Limited departmental examination.
So examination can take place, you can also take part,
No, my
maybe
lord.
the,
At present, my lord, the private respondents, the applicants of this IA, we were already promoted to health supervisor. Now we're in the post of health supervisor. But subject to the outcome of the writ petition, if the writ petition was allowed, that implies that the private respondents, some of them, will be demoted to health worker.
what I'm trying to say is, instead of, you're there, but let's discuss, okay? Instead of staying this order, this notification, they can go ahead with the examination, but the results can be withheld.
No, my lord.
Why not?
I cannot apply at this stage.
Oh,
this
you
post.
cannot. Why?
I'm already in the post of health supervisor at present.
So
But
then
my
what is your
promotion-
grievance?
My promotion is under challenge in the connected writ petition. And in the event the writ petition is allowed, the
Where is
present
the
applicants,
connected writ petition?
WPC number 85.
So you're saying that you're supposed to be promoted. We were already
promoted.
you are already a health supervisor,
Yes, my
isn't
lord.
it?
Yes, my lord.
So what, supposing they were promoted to be a health supervisor, what happens to you? What is the,
In the event the writ petition is allowed, and if it goes against me, us, we will be demoted to health worker. And this 17th post which is being advertised will not be having opportunity to apply for this post.
I'm not understanding. See, you're already a health supervisor.
And my promotion is under challenge in the connected writ petition.
Okay, in this writ petition.
Yes, my lord. So to avoid multiplicity of case and further complication, my lord, if this may be stayed.
How many people are affected? How many private respondents in this? How many people are eligible for sitting in the examination, LDE?
My lord, the applicants, there are
The respondents who are affected,
8
8 of them.
female, bottom
Okay,
8.
so you're not the writ petitioner
We are the
in
private
the
respondents.
connected writ petition?
Yes, my lord.
Oh,
At present, the writ petition.
what is the stage in the writ petition?
In the writ petition, my lord, the private respondents as well as the MPSC had already filed their respective counter affidavit. But due to filing of recast writ petition, the state respondents are yet to file their affidavit.
Yes, what do you have to say in this matter? This is concerning the stay till the disposal of the writ petition.
The affidavit will be filed in the course of the day. We will be filing in the course of the day.
IA, written objection.
No,
In the IA, okay, but in the IA, we're talking about the IA, we are we are dealing with the IA right
My
now.
lord, I received an instruction to file the objection.
So let them file a writ, we'll give them a short date,
Yes, my lord.
okay? Yes, because you see, in the interest of all, simply objecting, but you have to give a reason as to why it should be objected. Here it appears that supposing the writ petition is decided against their favor, then this, going ahead with this advertisement would be very different then. Anyway, we'll give you a short,
That regard,
yes.
my lord, it's.
You are
uh,
representing
it-
the private,
I am representing the
opposite party.
petitioner in the main writ petition. my lord.
okay,
And so far as our stand is concerned, the present recruitment of the LDE is completely different with the.
so
with
we'll
regard
see,
to the
we'll see.
present
So
petition,
file
my
your written objection,
lord. And my
okay?
lord,
Yes,
with regard to the main writ petition, my lord. The matter was delayed due to the termination of the council who had taken up the case on behalf of the state. And after the appointment of the new council, time was prayed and it gets delayed.
Okay, so we'll see.
Yes, my lord, the matter is taken up by Mrs. Mary, actually. So she will be filing her
Okay,
affidavit.
so we'll fix a short date
Your Lordship, may I
in the
please-
IA, in the
may I
IA.
please-
Huh.
I am counsel for MPSC, just to assist the court to know the process we have.
Huh.
As of now, this notification.
What is happening? Huh?
Yeah, notification that 7 April 2025 is purely from different sanction posts. And the process we have is that now we are preparing question. This is the process. It's gonna take time. So
So
this
no,
will
no,
take-
no, not such. So you file your written objection,
Definitely.
explain the position, then we'll see.
Sure,
Isn't
sure,
it?
sure, Your Lordship will do that.
So in the IA, this is 8, is it? Yes. Mr. Victor L. Ralte, learned counsel for the applicant, is present along with Mr. F. Lal Engliana, learned counsel for private respondent, private opposite parties number 1 to 9, is it? And Mr. J.C. Lal Nunsanga, learned counsel for
MPSC.
learned standing counsel, is it?
Yes,
For
Lordship.
for respondent number 15/MPSC and Mrs. Vana Isami, learned government advocate for respondents number 10 to 13. Okay. The learned counsel for the opposite parties have prayed for time to file their written objection. In view of the above list, after 2 weeks, 2 weeks. Then in the writ petition, Ms. Vani Siame, is it?
Yes, my lord.
Learned counsel for the learned government advocate for respondents number 1 to 4 has prayed for further time to file the counter affidavit. In view of the above list, after 2
My lord,
weeks.
if the matter may be fixed by giving a short day, my lord, in that regard, what I'd like to submit is that, my lord, one of the respondents in the main writ petition, it's the respondent
Okay, make
number
it 1
52.
week if you're prepared. If you're ready by 1 week, we can fix it after 1 week. Written objection in the IA.
My lord, yes, I can finish up within a week, my lord.
In the IA.
Yes,
In the
ma'am.
writ petition is only the
Madam.
government. But
Madam.
we'll dispose of the IA first and then this thing, writ petition can continue, isn't it?
It can go
So
together
in the
also, madam.
IA,
No, actually,
It can go together.
I actually MPSC is important.
so you file your written objection.
So, my lord, I'm leaving tomorrow. I'll be coming back 7. So 2 weeks is. Yeah,
Okay,
sufficient.
list after 2 weeks on, let's have a fixed date. Let's fix a date on. Okay, on 12/6/2025. What?
Just 1 second, my lord.
Ah,
What I would like to submit is that one of the incumbents, respondent number 52, will get her retirement this month. So that will become infructuous in connection with this.
but then MPSC is still going to take time. So just because of her, MPSC is not going to push the matter, isn't it?
My lord, that's
Oh, that's
my,
there.
that is my submission. my lord.
Okay, anyway, list on, what did we say? 12/6/2025, yes. You want us, now your submission is with regards to the IA? Or the writ
No,
petition?
No, with regard to the main writ petition, my lord.
No, now in the main writ petition, so-and-so has prayed for further time to file the counter affidavit. The learned counsel for the petitioner, is it? Submits that one of the petitioner number
52.
52, is likely to,
Respondent, my lord. Respondent. 52.
respondent?
Respondent number 52 in the main writ petition. I mean 51. Respondent
Submit,
51. London,
the
we-
learned counsel, Mr. F. L. Engliana, But here your name has been recorded as counsel for the petitioner.
That is correct, my lord. What I mean to say is that
You're for the petitioner, don't say anything for the respondents, leave it. See, you're the counsel for the petitioner.
I know that, my lord. What I want to say is that
Then let the counsel for
respondent-
the respondent make
res-
that submission.
Yes, the respondent number 51 is presently the health supervisor, my lord. And supposing in the event of
No, I think you are confused. Because the petitioners are only 9 numbers.
yes,
The petitioners are Mr. Laltandiana and 8 others.
Correct,
And
madam.
you are talking about respondent number 51. But you are the counsel for the petitioners, so leave it. Don't make a mention for the, it's not ethical. Okay, yes, so just leave that. Let the counsel for the respondent make that point. Why are you pleading for the respondent while you're the counsel for the petitioner?
actually, my lord, I'm not pleading. What I want to say is that
Don't make any submission on their behalf, leave it.
yeah, I'm not. Yeah, my lord, my lord.
Leave it. You inform the counsel for the respondent number 51 or 52, I'm not sure, and let them make this thing, the submission, not you,
My lord.
isn't it? Yes. So it's on 12th.
Item number 9 and 10.
Yes, my lord. I'm seeking another week time, my lord, on
What's
behalf of
happening?
Mrs. Mary.
What is the IA about?
If I may, this IA, earlier this case was handled by our station council, and subsequently I was appointed. And after examining the writ petition, there are some typographical
Okay.
errors.
Typographical errors. Let's see the nature of the error.
Page number 4, my lord, page number 4,
four.
para 2. May I read?
Yes, please read.
The applicant stated there had been an inadvertent typographical error in the said writ petition and the same were detected belatedly. The particulars of those errors are shown below. Number 1, the impugned order dated 30/4/2002 and closed as NSO 16 has been inadvertently mentioned as 30/4/2022 in the following lines, A, B, C, D to F, my lord.
Okay. So these are small
Yes, my lord.
typographical
But since
mistakes.
it involves
Yes.
several pages. And number 2, my lord, Roman number 2, on the bottom of page number 4. The order dated 7/4/1999 inadvertently written as 7/4/199 in the 8th line of para 8.
Okay,
And
but,
then again on page number 5, my lord,
okay,
Roman number 3.
okay, those
This is Mizo
typographical.
vernacular.
Okay.
So my humble prayer is that if I may be allowed to make replacement of the relevant page of this in the writ petition.
Now, but what is the stage in the main writ
The state
petition?
state respondents have already filed their counter affidavit, but they have not raised any objection to these particular dates. So no prejudice would be caused. to
Affidavit
the-
in opposition has not been filed.
Already filed,
Rejoinder is also there.
already filed. But
Oh.
the state had not made any objection against the particular date which I'm seeking to make correction.
We'll have to issue notice. Isn't it? Because if it was at the initial stage, you would have allowed you, but they have filed this thing, then
I
they'll
understand
have
that, my
to,
lord. I have
So
made
we'll issue notice.
I have made a specific governments at para 3, my lord, in my application.
So, yes, so we'll issue notice,
lord.
then let's
Yes,
see.
ma'am.
Uh, Yes, heard Mr. Victor El Ralte, learned counsel for the applicant, who has filed the instant application. Which provision of law? Is there any provision?
No, my lord.
At least something you should have mentioned, 151 at least. Isn't it? At least 151 has filed this application for making correction to some typographical errors made in the writ petition number 141/2023, which he submits was made, which he submits was deducted at a belated stage. So he further submits that the corrections which are required to be made due to the inadvertent typographical mistake have been listed out at para 2 of the application, para 2 and 3.
Para two.
Para 2 of the application. On hearing the submissions made by the learned counsel for the applicant, notice be issued to the respondents. Then Ms. Vani Isyami, learned government advocate, accepts notice on behalf of the state respondents. Number 1 to?
1 to 5.
Okay, on behalf of the state respondents, full stop, okay? No need to issue formal notice. Copy of the IA to be duly furnished to the learned counsel, government advocate. List after, when do you want it, 2 weeks?
2 weeks, yes, my lord.
List after 2 weeks, yes.
Much obliged.
Item 11.
Yes.
May I please, Your Lordship? My Lord, the order dated 13/12/2021 that was passed by the learned senior civil judge 4, eyes only, in Manisud number 95 of 2014 was challenged, and this honorable court has set aside the said judgment judgment dated 13/12/2021, which was passed by this honorable court in RFA 12 of 2022. And
Okay, the IA is for review petition.
IA is for delay condonation, madam.
No, IA is for condonation of delay in filing
Yes,
a review
review
petition
petition,
against the
madam.
judgment of this court. Okay,
Yes,
will
my
issue
lord.
notice.
My lord.
Heard Mr. Chilal Zakima, learned counsel for the applicant who has filed the instant application under Section 5 of the Limitation Act, 1963, for condonation of 299 days in filing a review petition for review of the judgment and order passed by this court dated 21/06/2024 in RFA number 12 of 2022, arising out of Manisud number 95 of 2014. Yes, issue notice to the opposite parties through registered post with AD within 3 days,
My lord.
returnable by 3 weeks. List after 3 weeks.
Duly obliged.
Item 12 and 13.
Yes,
Lordship, in this matter, we have filed an IA, that is IA number 81 of 2025. This is an application for a stay of the execution proceedings, Lordship. We have filed an RSA in this honorable court, and notice has been issued upon the respondent, and they are represented today.
so RSA is there. Then in the meantime, the execution case was not stayed, is it?
It was
in the
not stayed
RSA?
yet, yes.
Lordship,
Yes.
if I may, we have already submitted our vakalatnama. However, as of today, we haven't received any notice
Yes.
on behalf of
So
the
we're going to
we have-
issue notice, we're going
Yes.
to issue notice now.
Yes.
isn't it? Then you will go ahead, yes.
Lordship, but however, as per this, if your Lordship may kindly come to page number 15 of the IA, this is the order passed by the executing court. This is order dated 24/4/2025. Lordship, the relevant portion is page number 17. Coming from
Yes.
the third last para, Lordship. Hence the judgment debtor. Hence the judgment debtor are directed again to vacate the suit premises and deliver possession of the same to the decree order within 30 days of the order. Further, OC Vivacon PS is directed to ensure compliance of this order without any further delay. And with this order, CMA so and so, arising out of execution number 74 of 2022 is disposed of. And with the above, the instant execution case number 74 of 2023 is disposed of. Lordship, this executive court has given us 30 days to vacate the suit property. So these 30 days is going to be lapsed on this Saturday, coming Saturday. So if interim stay may be granted at
We'll
this
stay
point.
till the next date,
Yes.
returnable date, isn't it? Heard, Mrs. Malswamy, learned counsel for the applicant, who has filed the instant application under Order 21, Rule 26, read with Section 151 CPC, for stay of the operation of the order dated 24/04/2025 in execution case number 74 of 2023, arising out of title suit number 4 of 2015. Full stop. The learned counsel submits that though the connected RSA 4 of 2025 is still pending before this court, the learned court in execution now, case number 74 of 2023 had passed an order directing that the applicants should vacate the premises within 30 days, is it?
Yes, within 30 days.
Right, it's order dated
24/4.
24/4/2025. She therefore submits that unless an interim stay order is granted, the applicant would suffer irreparable loss. Full stop. She further prayed that instead of interim stay, unless the state order is stayed till the disposal of the connected RSA 4 of 2025, the applicant would be suffering irreparable loss. Then, having heard the submissions, notice be issued to the opposite party / respondents. Full stop. Mr.
Arlal Hunsiama.
Al-Nusiama accepts notice on behalf of the respondents. Full stop. Then, requisite copies of the IA to be duly furnished upon the learned counsel for the opposite parties / respondents. Full stop. Then, Mrs. Malswamy, learned counsel for the applicant, further submits that unless an interim stay is granted, the applicant would be suffering irreparable loss in view of the order dated, impugned order dated 24/04/2025, when the applicant is required to vacate the premises within a period of 30 days, and that 30 days would lapse on, what's Saturday?
Saturday is 24,
On
24 5.
24th of 5/20/25. Stop. Considering the nature of the submissions made, this court find it fit to stay the operation of the order dated 24/4/2025 till the next returnable date, list after 2 weeks. 2
Lordship,
weeks.
if your lordship may, the case may be taken up next week, because
For you to file a written objection, will you be able to file?
yes, my lord.
Okay, list after 1 week. Meanwhile, the learned counsel for the opposite party may file their written objection, if any. Yes. So in the RSA, anything to be passed?
We have to first
What
dispose
is
of
the
the
stage?
IA. It is in the admission stage, Lordship.
Here, the operation of the judgment
Yes.
in
Yes,
the
operation
title
of the
suit is
judgment.
already
Yes.
stayed.
Not yet stayed, Lordship. That was to
Okay,
be
will be
considered.
considered
yes,
in the next date.
yes.
And notice is issued.
Notice is
So now,
issued.
in this case also, the appearing Ms. Swami, learned counsel for the appellant is present along with Mr. So-and-so. Lal Hunsiama, learned counsel for the respondents. Any other party?
No, my lord.
Sole respondent?
Yes, my lord.
Sole
Okay,
respondent,
okay.
Lordship.
Learned counsel for the sole respondent. List this matter along with the IA 81/2025. Yes.
Deeply obliged.
Hearing item 1.
My lord, in this case, my lord, may I please,
hearing.
lordship? In this case, I have sent a judgment of the apex court, my lord, through the WhatsApp messenger to the pescar of this court, my lord. This is, my lord, pescar of this court, my lord, and this is, my lord, 2008-12 SCC, my lord. This is judgment, my lord.
Okay, wait, let's come back. What is it?
Yeah.
We had heard
Yes,
the
ma'am.
matter, is it?
Yes, my lord. Already at length, your lordship heard this matter regarding the issue of the framing issue, my lord, because this hour in WS, lordship may turn page 14 of this page 14.
Okay, page 14 of the paper book. Don't rush, okay? Page 14 of the
Yes.
paper book.
And relevant page is page
See,
16.
we have to come back to what was it that we have heard? Page 14, yes.
Yes. Page 14 is our written statement. And thereafter, page 16 our objection, page 16.
Your written objection, okay. Page
And
16.
page 16. The paragraph B.
Okay, facts of the case was what?
Next of the case was this: we raised the question of non-gender and mid-gender necessary party. The work was carried out by the contractor. Our grounds of the appeal is your lordship may turn. This is mainly 105. These are our grounds, main grounds.
I have to
Of the paper
recollect
book.
what is it about. I'm completely lost like now, but if I see something, I will. Page
My lord,
105.
my lord, it is a damage suit, my lord. The decree was in damage suit, my lord. This railway was there's construction railway, my lord. The contractor was carried out the construction, my lord. So far, my lord, 105 is our ground, my lord. Lordship may this I'm reading the 105, my lord. D.
Wait,
For railways,
wait, page?
page 105.
See, there's no page 105 out here. Page
My lord, this is
56, page, yes,
book, my
yes,
lord?
yes, now I found, page 105 of the paper book. Yes,
Yes, ma'am. G is ground G. For
Yes.
that, the railway is constructing a new railway line from Bhairavi to Sairan by engaging different agency contractor for different work at different location by awarding work through contract agreement under general condition of contract. Some clause of the GCC is below. Clause 55.1, the contractor shall not be permitted to enter on other than the inspection purpose or take possession of the site until instructed to do so by the engineer in writing. The portion of the site to be occupied by the contractor shall be defined or shown in the site plan, or this shall be indicated by engineer, and the contractor shall not be used or allowed to be used the site so allowed to him by the railway for any purpose other than that the executing the work. The contractor shall make his own arrangement at his own cost for any additional land required by him for purpose of execution of work. Then clause number 5.3, the tenders before putting his rates shall carefully inspect the site and shall deem to be satisfied himself about the nature and type of work, indicating ancillary work necessary for satisfaction of execution work. Site accessibility, availability, and required materials need to be suitable roller compaction of artwork, drying and wetting of soil before compaction, enhancement of the staging, so and so, so and so, so and so. 3. Clause 8.2. The rate of all items is equal to be included the cost of all arrangement for crossing frequent all obstruction in course of work over or across the water, and the cost providing and maintaining approach service road and temporary breathing and moving construction plan machinery materials to and from the site of work, including the rent of use of private land or compensation for damage, if any, due to intervening private land renders by the such approach service. As mentioned above in paragraph D1, the railway executing the work by developing different contractors for different work at different locations as GCC clause so and so. Railway never allowed a contractor to execute the work beyond the required land. Also, contractor shall make his own arrangement at his own cost for additional and required by him for purpose of executing the work. Accordingly, when required agency has obtained NOC and made an arrangement to use land of one so and so, as such, railway is not liable to pay compensation to the plaintiff respondent 1 to 3. Here, in damage suit, the only the railway was the made party defendant. My lord is hearing me?
okay, wait, is the contractor represented today?
No, my lord. The contractor was not made party respondent, my lord. That was the in our WS in page 16.
Then they have to be made a party.
Yes, my lord. They showed it when damage suit was filed, my lord, it was not party. So that issue was not framed, my lord. So on last occasion, your lordship asked the question whether there is any supporting judgment or if there is any law. So far, I understand the law,
So
my lord. Law.
this is an appeal. So in your appeal, you're saying the contractor is a necessary party.
Yes, my lord.
So
Because
let's see the
that was
judgment.
not- My lord?
2008, is it?
Yes, my lord.
2008, 12 SCC 372. Para?
But this, in my page, this is paragraph 10.
Para 10.
10.
Oh.
And before that, your lordship, my lord, before that, I am reading 107, section 107 of CPC.
Okay, 100 and CPC.
Yes, my lord. Section 100 and CPC
But
speaks, my lord.
you are the appellant, so you're saying contractor will have to hear the other side. 100 and?
107. Section 107. The power of this court, my lord, the power of the appellate court, my lord, subject to condition and such condition and limitation may be prescribed. The appellate court shall have power to determine the case finally, B, to remand the case, to see frame the issue and refer them for trial. I am on frame the issue and refer the trial. My lord. This is A, my lord.
Yes, yes.
And thereafter, your lordship, the another clause in the dear my lord, this my lord, so for order 41, rule 25. Order 41, rule 25. Where the appellate court may frame issue and refer them for trial to the court whose decree appeal form. Where the court from whose the decree the appeal is preferred has omitted to frame or try any issue or to determine any question of fact which appear to the appellate court essential to the right or decision for the suit upon the merit, the appellate court may, if necessary, frame issue and refer the same for trial to the court from whose the decree of the appeal is preferred. And in such case, shall direct the court to take additional evidence required. And such court shall proceed to try such issues and shall return the evidence to the appellate court together with its findings thereon and reason thereof for so and so, so and so. So this, as per provision, also this the Eurolordship has a power to frame issue in this regard. So my objection was, my lord, this while construction was carried out, the petitioner never filed an objection before the district lordship, and I had not informed the railway authority. And after ongoing completion of the they filed an instance suit
You're
compensation
reading
for
from
damage.
where now? You're reading from where?
Page 16, my lord. This is page 16.
Page 16.
16, my lord. B, my lord.
Yes.
From the B, I'm reading the last line further. B, paragraph B further. It is while mentioning there the railway construction is carried out by private construction company and not by railway authority, who ought to have been made necessary party to the case, and hence the entire plan is defective and liable to be struck down, and this is on the ground the plaintiff has not filed as per the so and so. So this issue, this was the objection. This issue was not framed. Now it was not decided whether he is a necessary party or not. So, but my lord, I'm coming. My lord, is the report of the joint short verification report, my lord. Once, my lord.
Page?
Yes, my lord. Page, my lord, 55, my lord. So-and-so, Mr. Land is located inside Cambrian area between the railway tunnel and tunnel so-and-so, and contract under railway department. Here is NC Das company. This is the company.
Where?
Here
Page
is
55. You're reading page 55
Yes, my lord.
of the paper book.
Yes, my lord. So NC Das company, they are the contractor, my lord.
This is the report of the surveyor.
Yes, my lord. Then this only survey was called for court witness, my lord. He was examined, but he was not cross-examined also, my lord.
Okay, so
Madam,
page 55, surveyor not examined.
Not cross. He is examined, my lord. He was not cross-examined, my lord.
Okay.
He was not cross-examined, my lord. Page 55, page 61, my lord. 61 also same, my lord.
Why was he not cross-examined?
My lord, this was not, there is no whisper. Last occasion, we have gone through the order record, my lord, of the LCR record, which is before your lordship. There is no decline to cross-examine, so only just he was examined, and thereafter this judgment was passed, my lord. And lordship may turn page 61, my lord, page 61. Mr. So-and-so land is located inside the Kamrang area between railway tunnel, so-and-so. The work is performed by NCDAS company under railway department. He is the contractor, madam.
Okay, performed by NC Das Company.
NCDAS company, madam.
Okay.
So, my lord, this question was raised, the issue was raised before this trial court, my lord. This issue was not framed, my lord. So, and my lord, this another thing is I'm just trying to point out this the judgment, my lord. Judgment, my lord. Your lordship made the judgment is starts for page 71. Page 77 is the preliminary part, madam. Page 77. Paragraph 8.
Yes.
My lord, the learned court below, my lord, is mentioned is our objection, my lord. The plaintiff did not file any objection before defendant or not. They informed the relevant authority regarding damage. Defendant to further stated the construction is carried out by private company, not by relevant authority, and that the private company ought to have necessary party. This was, my lord, is reflected, but the issue, my lord, lordship may turn page 80, the issue was framed, my lord, page 80. There is Roman 1 to 7, my lord. There is no such issue, my lord, regarding, my lord, and this neither, my lord, they discussed nor, my lord, they rejected also, my lord.
Okay.
So my basic thing is, as per provision of the law, my lord, this honorable court, my lord, this as appealated court, my lord, can frame the issue, my lord, and may refer them for trial again, my lord, as for section 107 of the CPC, as well as provision, my lord, this order 41, rule 25 of the CPC, this court has provision. And my lord, same thing was discussed, my lord, this judgment, my lord. This judgment, my lord, this report, my lord, this 2008-12 SCC, page 372, my lord. Lordship is there. Your lordship is getting, my lord, this judgment, my lord.
Yes. Para 10. Read.
Para 10. A BR provision makes it clear that that the same came to the operation when the court whose decree is preferred has omitted to frame or try or issue or to determine any question of fact which appears to the appellate court essential for the right decision of this suit upon the merits. In order to bring the application so the appellate court must come to the conclusion that the lower court has omitted to frame issue or has failed to determine any question of fact which the opinion of the appellate court are essential for a right decision of the suit on merit. Once the appellate court come into conclusion, it may, if necessary, frame issue and refer the same to the trial. In other words, there is no compulsion of the part of the appellate court to do so. It is clear from the use of expression may, but the further question that arises is whether in such cases appellate court is bound to direct the trial court to take additional evidence
Para
required.
11. Para 11.
My lord? My lord.
Wait, yes, Yes, please read, continue.
Yes, well, further question that arises whether in such cases the appellate court is bound to direct the trial court to take additional evidence required. This is a mandatory requirement as as is evident from the provision itself because it provides that the lower court shall proceed to try such a case and shall return the evidence to the appellate together with the findings therein and the reason thereof. As noted above, the provision becomes operative when the appellate court comes to the conclusion about the omission on the part of the lower court to frame or to try issue. Once appellate court directs the lower court to so, it is incumbent upon the trial court to take additional evidence required. As has been rightly contended by learned counsel for the appellant, there may be cases where additional evidence may not be required, but there is a additional, but where there is additional evidence is required, then lower court has to return the evidence to so recorded to the appellate court together with findings thereon and reason thereof. Requirement for recording the facts findings of the reason disclosed from the facts. It is because the appellate court at first instance has come to the conclusion lower court has omitted to frame or to try issue or determine any question of the material for a right decision of the suit on merit. It has to be noted there is a finding is called for on basis of certain issue framed by the appellate court. The appeal is not disposed of either in whole or part. Therefore, parties cannot be barred from arguing the whole appeal part findings after the findings are received from the court censor. So, my lord, in this case, my lord, this honorable court has every right to frame issue which was raised by the us in our WS, my lord. So this case was, my lord, initially, subsequently, my lord, the appellate court referred when the trial court subsequently framed additional issue, my lord, then they approached the high court, my lord. High court says no. The appellate court has the power to, my lord, from frame issue, my lord. So ultimately, this apex court also agree with the findings of the high court, my lord, from paragraph 37, my lord. So this is not sufficient before the honorable court, my lord. The contractor it was carried out by the contractor with this. There is an agreement between the railway and the contractor, my lord. And our ground is specifically we mention it from G, my lord. The railway has it is duty of the contractor to pay the damage. Railway is not appropriate authority to pay damage. This is the humble submission before on. Lordship, so therefore the lordship may issue frame in this regard and may refer back to trial court for final decision.
Yes. Respondents.
May I please your lordship, I will present the respondent number 1 to 3.
1 to 3.
Yes.
Yes.
Your Honor, I'll start with page number 17, para H of paper. It is a written statement submitted by the appellant with your permission, may I read?
Yes.
Para H, that joint survey spot verification with DC scholarship with the presence of all the parties are necessary to find out the actual damage caused to the plaintiff land, if any, while construction of the railway line from Bairobi to Saira. Here, I would like to elaborate that regarding the submission of the appellant in the trial court. Joint spot verification was derived, and on 3/3/2019, a joint spot verification order was passed. Your Lordship, on page number 78.
78.
Yes, para number 11. May I read? Pursuant to the above order, 3rd March 2022, by this court, the JSV was directed by this court to conduct on 19/4/2022, and the same was filed by the SO Colosseum, and this court expressed its appreciation of the same prompt action of the SO Colosseum in complying the direction of this court. Name, designation, and signature of all the individual present in the JSV was also attached with representative of both sides are clearly indicated to be present thereof. The report was submitted on 2/5/2022. The parties have been made aware of the content of the report. On 8 June 2022, the joint verification report was perused. On perusal of the report, it was found that plaintiff have a valid cause of action and the land was damaged by the defendant to the extent verified in the report. On agreement of both parties, the surveyor conducting the JSV was called to give evidence at court witness. In order to expedite the process of trial, waived to submit, produce witnesses, and sought to rely on the JSV finding. On 8 June 2022, hearing was conducted on the JSV report. After perusal of the documents and hearing the parties, it was ascertained that damage had been caused to the land of the plaintiff. Now, I'm coming to para number 13, page 80. May I read? Submission of the learned counsel of both sides was also thereby heard, whereby both sides consider it sufficient to adduce only the evidence of the surveyor who conduct the JSV and file report of the same. Here, I would like to submit that both the parties have submitted their consent for having a joint spot verification, wherein all the parties will rely on the basis or on the finding of JSV, and in our case, the plaintiff also, the respondent number 1 to 3 also rely upon the JSV. Your Honor, I would like to submit that regarding the contention made in respect of non-joinder of necessary party. I would like to take on page number 16.
60.
16,
16.
of paper book. My learned friend had read out the whole content, but I will not reproduce the whole. I would like to submit that in this regard, in my opinion, the name and address of the contractor has to be fully supplied before the court. A mere submission that there are so many contractors engaging construction work cannot be accepted, and hence the submission of the learned friend, in my opinion, is lack of merit. And with regard to non-cross-examination of the surveyor, on the day when the surveyor was examined before the court, both the parties were present, and we declined to cross-examine him. In this case, I have a citation.
Yes.
This is,
Say the citation. Huh.
this is a case between Union of India and Susaka Private Limited and others.
2018.
2018 through SCC 182.
182. Yes. This is concerning Arbitration and Conciliation Act, isn't it?
Yes, but on para number 27, page 187. May I read?
Yes.
Para number 27. If a plea is available, whether on facts or law, it has to be raised by the party at an appropriate stage in accordance with law. If not raised or and given up with consent, the party would be precluded from raising such plea at the later stage and the proceeding of the principle of waiver. If permitted to raise, it would cause prejudice to the other party. In our opinion, this principle applied to this case. What I want to submit is that the appellant has the right, while the surveyors examine, they have raised or made an application for recall of a witness. However, no application or plea has been raised at that time.
Yes. Then?
Then the appellant is barred by principle of waiver in this case. And what I would like to state is that the whole content of the judgment, and the judgment was derived from the consent regarding having joint spot verification, and solely rely on the finding of the verification report. And as such, the trial court passed the judgment and decree. In my opinion, there is no such error on the part of law, and I pray this honorable court to dismiss this instant appeal for the ends of justice.
Yes. Yes. Government advocate.
Hello, my lord.
Let the respondents finish
Yes,
first.
yes.
Lordship, I am appearing for the respondent number 4. However, I have not received any instructions, but my lord, I would like to rely on the written statement made by the defendant number 1 in the lower court. It's at page 25 and 26 of the paper book.
Today is fixed for hearing. You can't say instructions. You should be prepared. Paper book.
Page 25,
Serial number?
serial number 9. That the answering defendant never noticed any complaint by the plaintiffs within the acquired railway line. The plaintiff should have complained and initiated claims for the compensation during the course of construction period. It is surprising that the private landowners submitted complaints at this belated stage, which creates doubt, and even spot verification cannot ascertain the actual damage caused after a lapse of almost a decade. And point number 15. Award number 1 of 2012 was made by the answering defendant and payment was already completed. There is no initiation of acquiring the land of the plaintiff as there is no
So
complaint.
you're supporting the appellant?
Yes,
actually?
I'm supporting that.
Okay, fine.
Your Lordship, I would like to interrupt the submission of the London Government Council. What the damage has been caused to the respondent number 1 to 3 land is beyond the acquired area, not within the acquired area.
Yes,
My lord.
yes. What do you have to say, rebuttal?
Yes, my lord, my friend pointed out 3 points. Actually, point number 2, actually, I could not heard, but point number 1 and 3, my lord. If my lord, point number 2, what he argued, my lord, actually, I could not able to heard, my lord. Point number 2. There's 3 point here, his argument in 3 point, my lord. So far, point number 2, again, I want to hear.
No, you should be in present then if you can't hear, isn't it? What is your point number 2?
No.
My lord is hearing me.
It's
My
okay.
lord.
If you can't hear,
Yes.
you can't hear. Anything else? That's
Yes.
all?
No, my lord, the item, the page number 79, my lord. 79 is the 79, my lord. We already read this. So, of the paper book, my lord. This is start from page number 78, paragraph 11 of the judgment, my lord.
See, they are saying that cross-examination, you have waived your right because you were agreeing to it. What else? Both of you agreed to rely on the joint verification report, bus, for verification. That's his point.
Yes. My lord, the parties, in order to expedite the process, process of trial, we have to submit the and to rely on.
Yes, Mr. Vedi, you have
My lord is
disappeared.
hearing me.
We cannot see you and you
No, my lord is-
we cannot hear you also. Where are you? Yes.
Yes, my lord, I'm here, my lord. I'm here. I'm here. My lord is the parties, in order to expedite the process of trial, we have to submit the produced witness and sought to rely on so and so finding. On 8/6/2022, hearing was conducted on joint spot report. After perusal of all documents and hearing the parties, it was ascertained that damage has been caused to the land of the plaintiff. Page 79, madam. Damage has been caused, madam. Who caused, madam? It was the finding is not there, madam. Now the question that was left to decide upon the amount of compensation payable to the plaintiff, and in this regard, it was deemed most appropriate if assessment of the damage caused in terms of money is assessed by the district collector office is equipped with the requisite expertise and so for the same. Hence, court passed an order on 8/6/2020 directing so-and-so to make assessment as per so-and-so standing crops, plaintiff, so-and-so. My lord is already, my lord, before my lord, the evidence is taking, my lord, my lord, coming the consultation of the issue, my lord, already this on a learned court below, my lord, already decided the damage is there, my lord, damage is there. So it was settled and directed to the assess the damage, my lord. As far as this page 50 or 79.
Okay, so assessment and damage is not challenged. You're saying that it is a contractor and contractor should be a necessary party. I think that's your case, isn't it?
Yes, my lord. Then thereafter, my lord, in page 85 also, my lord, the exhibit C4, my lord, 85. Exhibit C4, my lord, last paragraph, my lord. Exhibit C4 is the report of PC pass so-and-so belonging to plaintiff number 2, so-and-so. In report, survey report that the plaintiff is within so-and-so area and located in railway so-and-so, and the construction is carried out by NC company. So my joint supervision report was received by them, my lord. It was mentioned, my lord, the name of the company, my lord. So exhibit, my lord, is reflect exhibit another 86, my lord. Exhibit C5 also this PC pass, my lord. Here also the NCDAS company is reflected. So it is the duty of the plaintiff, my lord, to make party. It is not duty of the defendant, my lord, they disclose, my lord. After receiving the joint supervisory report, my lord, it is clearly mentioned that this NCDAS companies, this construction was done. So my humble submission before this honorable court, my lord, this is completely, my lord, this on learned court below, even discussing everything, my lord, never framed that issue, my lord, and there is no whisper against whether he is required to be a necessary party or not, my lord.
Yes,
This is not
yes, sir, you have
as per
repeated
Apex-
yourself, I've heard. That submission you
Yes.
have already made. You have heard,
Yes, ma'am.
yes. Okay,
And
we'll
I-
make
I-
it a CAV.
Yes, ma'am. High level.
See, his main point is that the constructing company should also have been made a party. He's not challenging the other points, isn't it? So anything on that point?
Yeah, regarding that contractor, I would like to submit that at the time of filing written statement, the name and address of the contractor was not
Okay, name and address of the contractor was not furnished.
Mentioned.
Okay, fine.
But subsequently, my lord, the report, my lord, everything is there, my lord. Joint supervision report, they were also there, my lord. They were present there, my lord. When they were present, joint supervision report conducted, my lord. The plaintiff itself present on particular date, my lord. Where it was the surveyor report was itself speaks, my lord. Everything is with the NCDAS company is there, my lord. It is aware of them, my lord. My question is that a learned court below never framed this issue, my lord. It is duty of the court, my lord, to
Yes,
issue
we've
frame.
heard it. Are they coming?
Highly obliged, my lord.
The limited
May I leave?
past the order with the-
Hey, leaving, my lord.
Anyway, we'll make it a CAV. Yes.
My lord, I'm leaving, my lord.
Let me pass the order, not passed yet. Yes.
Today,
Heard
today,
Mr.
silver,
F.K.
they
Medi,
must-
learned counsel for the appellant, along with Mr.
RK Mustafi,
R.K. Malsom Kima, learned counsel for respondent number
1 to 3.
1 to 3, and Ms. Caroline K.L. Lungoipui, learned government advocate for respondents number
Respondent number 4.
4. Hearing concluded, matter reserved for order, for judgment.
Highly obliged.
Yes.
Item 7.
Now, hearing list item number 7. It's 5 minutes for.
My lord, even though this
break.
matter was fixed,
Uh,
after going through the case to court, which was supplied to this honorable court, there are certain discrepancies from the registry, your lordship.
Have we
Number one-
called for the LCR? Is the LCR available? LCR is there.
But Lord, I've gone through the NCR and the claimant witness number 1, the position is not there. OP number 4, the position is not there.
In the LCR?
Yes, ma'am.
But was evidence taken
Yes,
before
my
the
lord,
court?
we have the copy, but it's not there.
How come it's, maybe at the time, no, we cannot accept that
No, I'm
copy.
just trying to say that the name, the witness number 1
Okay,
your
let's
lordship will go
see the
through-
copy, yes. Okay, let's see the document which you have
Yes,
with you.
yes.
Just collect from him.
These are the two documents which are missing.
What is this defect replaced?
Earlier also we have submitted their certain defect before the coordinate bench of this court and for the registry to make some to rectify it, your lordship.
So you're saying these documents are not available?
not
That
there
is in chief.
In chief at the cross-examination of witness number one for the claimant, Zaubela. If your lordship will not just go through, I've gone through it earlier, I did not find, because that's crucial evidence.
My lord, I may please lordship. However, all the depositions and the cross-examinations, they reproduced in the judgment and order. It's in the front page, my lord. Roman number
But
1,
no,
2.
but those documents are required to be here, whether they're reproduced or not. From where did the court reproduce? That we have to see. In the judgment order, it's reproduced, but
My
from
lord, my
where?
lord.
Then we'll have to check and see the evidence, isn't it? So if it's not available, the trial court have to see. When was the accident? When did the accident take place?
2018.
25/8/2018, my lord.
18.
My lord.
So the claimants, any amount given to them of the award?
Not yet, my lord, not yet disbursed.
So at the time of admitting the appeal, no order was passed for a certain amount of the awarded amount to be deposited into the court?
25,000 rupees has been deposited to this
That
court.
is the statutory,
Statutory
only the
deposit.
statutory.
Nothing has been.
That has to be deposited, order is not even required to be made.
My lord, as far as my knowledge is concerned, my lord, nothing has been disbursed as of yet, my lord. I have compiled the orders of this honorable court.
But the documents have to be complete. So you take this copy, later you check with the registry, and if it's required, we can ask the trial court also.
And my lord, there are certain pages which are not where it should be. So the pagination given by the registry is wrong. Like for one example, your lordship.
But a paper book has been prepared. No, there's no paper book. So what pagination?
From the trial court's copy.
Trial court.
Because
then
the
within-
cross-examination of one witness is put in the cross-examination of another witness.
Okay, this is a scanned copy, it's not the original, isn't it?
Yeah, it's a scanned
Yes, yes.
And look, just for one example, page 63 in the scanned copy should be page 60. Because it is the cross-examination of another witness which was put in a different page. Page 63 should be after page 59.
Anyways, heard Mr. Jonathan El Sailu, learned counsel for the appellant, who submits that he has perused the LCR, the scanned copy, okay, of the TCR, not LCR, received from the trial court, from the learned tribunal, not trial court. Okay. Wherein the evidence of the claimant, is it?
Claimant witness number 1.
Claimant witness number 1 is not available.
And your lordship, the OP number, one second, your lordship.
Waiter, claimant number 1 and OP
the
number
evidence of the National Insurance Company Limited.
and the evidence of the
OP number
National
4
Insurance
in the
Company Limited, OP number 4.
in the tribunal. Yes.
Namely, Mr. Vopi.
Then never mind, it's not available in the scanned copy of the TCR received from the learned tribunal. He also submits that the pagination made in the scanned copy is not correct. Given an example of page 61, is it?
No, my lord, page 63.
Okay, given an example,
Should be page
giving an
16.
example of page 63, which should have been placed after page
59.
51, 59. Then Mr. Benjamin Lalsamwana, learned counsel for respondent number 126, is present. In view of the submissions made by the learned counsel for the appellant, this court find it fit to release this matter from hearing column, and the registry is to get the is to ask for the complete evidence or documents of the.
If I may, Your Lordship, if the case record is called, not a scan copy from that.
Okay, and yeah, I think that will be better. In view of the above, this court find it fit that the trial court records be called for, since only the scanned copies have been sent by the learned tribunal. Accordingly, TCR is to be called for and matter be listed.
May please, Your Lordship, my lord, this matter may be kindly laid before Your Lordship, my lord.
And matter be listed under the orders column after 2 weeks. You cannot choose a this thing, bench hunting, bench. It's not done.
My lord, applies.
Yes.
Scan of the argument can based on anti-non.
Oh, bị chiếc hả? Scooty này tôi không biết chị. Yêu lẹ đó. Như tao này.
My employee and
it's a continuation to
my employee. Case record then the top scan can scan kiếm lâu nữa sao? Lệ antenna này update sẽ lâu đằng ta antenna vô bị cái tree rồi à, phone khác vô bị cái phone rồi bị đằng phone. Thì ta là buổi
can confuse don't. LCR to start on tina. Lako lo scan chắc rồi.
Anh xét trường đủ chân đủ là receipt trong khám phone sẽ là.
Nia anh tot dan.
Anh hoa ngũ tỷ xe này mấy.
Anh đi xuống anh tot dan pujana shemi lo vào. Number bak kan mo.
Ông giờ chú witness number 1 hi mo. Witness number 4 tăng nên chân đấy à. Abuai no 4 so 5 kala chon 2 kala ya. Acha chú đã khăn soi no khăn page number à chú tí.
Acha chú mo. อันมานี่จะเป็นอันติชวนเพจอังคารนั้นกำลังดิกเลดอนชวงเราทุกขดิกเราว่าเห็นเขาว่าไงอันนี้น้อยนี่
đồ lại cái đấy cái phần của đâu là nó lót lan đấy nó
มันบอกช่วงรู้เลย